And those are 8 minutes.
I will use 3 minutes, then my learned friend will proceed. Mr. Speaker, sir, pleadings in respect of this impeachment were closed on 1st of December 2025. All parties were required to file their respective document as at close of business on 1st of December 2025. There has been no attempt by the County Assembly to respond by way of affidavits, controverting the affidavits that are on record by the 4 MCAs. None. They had that opportunity, they did not do it. And therefore, in respect of that piece of evidence, it is uncontroverted. That is the position. That is a fact that has been admitted because they had the opportunity to file their own affidavits to respond to this issue. They have not. And therefore, we are squarely within the mandate of a PO because this is a fact that is not controverted. Secondly, and lastly, Learned Council has sought to seek refuge, understanding order number 1 of the County Assembly of Kericho. Let me remind him what the Constitution states at Article 181, that Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds specified in Clause 1. Pursuant to that power, this House enacted Section 20 of the County Governments Act, which, in case Learned Council has not read, states as follows: except as otherwise provided by this Constitution, this Act, the County Governments Act, or in any other legislation, any question proposed for decision by the County Assembly shall be determined by a majority of the members of the County Assembly present and voting. Can you be present in absentia? It's an oxymoron. When he runs and seeks refuge at Standing Order number 1, Order number 1 provides for issues that have not been expressly provided for. Section 20 provides for the voting procedure. Therefore, the Speaker cannot run and innovate when there is a clear provision of the law. Thank you, my learned friend.
Mr. Speaker, thank you. For the record, my name is Zelma Bunuke, Counsel for the Governor. I'll address the issues that have been referred to by the other side of the County Assembly. I've heard them urge the issue of Kericho and how the proceedings of this House were concluded. It will be noted and on record that upon the proceedings being terminated, the Senate resolved to vote on the PO first before delving into the other grounds. What then does that mean, Honorable Senators? We do not have to waste time on an illegality at this phase. As my colleague said, the Honorable Senators have a lot to do, and we have highlighted a significant point or question of law on the threshold. Let me take you through what constitutes of the Nyamira County Assembly. It has got 20 elected members, 11 of which form the part of the gender top-up, 4 in the marginalized category. That is 35. Nothing changes. I will put contexture to that while referring to the Constitution of Kenya under Article 138 on the election of the President. Allow me, Honorable Senators, to refer to Article 138 4A, which says, in a presidential election, a candidate shall be declared elected as a president if the candidate receives A, more than half of all the votes cast in the election, and at least 25% of the votes cast in each of more than half of the counties. Honorable Senators, we have 47 counties in Kenya. Half of that, my quick math tells me that is 24. Therefore, the express provision of this, of the Constitution, is that we cannot then say that if 38 counties voted, then they did not meet the threshold, because the law is clear that they have to be more than half of it. So what you're being told here is that we need to subtract the members who are not present and then lay the basis of having the 2/3. Allow me to refer to the Constitution once again on the process of the removal of a governor. It's very clear. It is not something that has been created out of anything else, but it's in the Constitution. The framers of the Constitution were very specific under Article 33(1), and I will read Article 33(2). Sorry, this is the County Government Act, Section 33(2). It is specific that a motion under subsection 1 is supported by at least 2/3 of the members of the County Assembly. This, honorable members, is a specific motion. It is not a bill or any other motion that can be brought to the House. It is particular to the removal of a governor. We do submit, honorable senators, that even if the County Assembly Speaker sought to create his own rules on how to conduct this voting exercise, then the standing order number 1, which they have sought to rely, is very specific, and they have read selectively standing order number 1(1). What they didn't tell you is that standing order number 1(2) provides as follows: the decision made in paragraph 1 shall be based on the Constitution of Kenya, statutes of law, and the usage of forms, precedent, custom, procedures, traditions of the County Assembly of Nyamira, the County Assembly, and the Republic of Kenya within this jurisdiction. They have failed to refer you to any statute that provides for proxy. You have also been told that this is a norm at the County Assembly of Nyamira to use proxy voting. Then we pose this question, honorable senators. Should we then countenance an illegality on the face of it, which has these serious ramifications, including impeaching an elected governor on a basis that does not exist in law? Honorable senators, we urge you to consider our preliminary objection, and especially on this point on the threshold. If you are told that the issue of proxy have to be called as witnesses, that is fine. But then have we determined the first question on whether this motion met the threshold? The answer is a resounding no. We yield to that, honorable senators. Thank you.
Now, honorable senators, we have 6 minutes. Kindly shoot straight so that we can extract the most out of these 6 minutes. Senator for Nairobi City County.
Honorable Speaker, very interesting arguments have been made about membership, and I want to seek clarification from Council, especially Council for the Governor. On the question of membership, you have stated very well what Section 33(2) speaks about, that motion has to be supported by 2/3 of all the members of the Assembly. I want you to tie that to the provisions of Article 103(1)(a) on vacation of office. Upon the death of somebody, can that person be still referred to as a member of the Assembly for purposes of determination of membership? And therefore, Speaker, there is a very interesting point that was raised by Council for the Assembly. For instance, Speaker, if by catastrophe we have 35 members in the Assembly, 15 of them are in a bus, and the bus plunges into a river and they are no longer members of the Assembly. If an issue of impeachment were to arise in determining 2/3 of those members of the Assembly, is it the case for the governor that we will still use the number that was determined at the election in August of 2022? Thank you, Honorable Speaker.
There's Counsel for Governor.
Thank you, Mr. Speaker, sir, and thank you, Senator for Nairobi, for that question. My straight answer to that question is the impeachment process is governed by 3 pieces of legal provisions: Article 181, Section 33, and the standing orders. It does not anticipate a scenario whereby there will be a vacant that will have to last for so much, or rather for so long, such as to affect the business of the House. And let me just give this as an example. Assume that for a moment, half of the House is not present, either by tragedy or disaster. What happens to that House? Do we then reduce the threshold to the remaining 10 or 5? We cannot do that. So if there is a vacancy, it does not affect the threshold because the law has a mechanism of filling that vacancy. That would be my short answer to that issue. Thank you.
Senator Wambua.
Mr. Speaker, I have a similar question, but this time to the Counsel for the Assembly, Katwa Keegan. Mr. Speaker, I want the lawyer to address me and address this House on the question of the membership of any assembly. At what point does that membership determine? Does it determine immediately after elections and after political parties have had an opportunity to discharge their obligation to nominate members? Or is it a moving target? Is it one number today, a different number tomorrow, a different number next week? At what point does this number determine? I thank you, Chair.
The Counsel for the County Assembly.
Thank you, Mr. Speaker, sir. It is the direct answer to the question from us is that it is a moving target. The reality of it is that at every given time, the representation has to continue. Various activities have to be done. There is need to approve budgets. There is need to determine issues. And therefore, the fact that there is a continuous need to attend to issues on behalf of the public makes it a moving target. And at every given time, the people who are available to transact the business on behalf of the people who elected them is the determining factor of the total bottom line number of people who are to vote. That's my answer to the question.
Senator Boni.
Mr. Speaker, I'm convinced by what the Counsel for the Governor Mutuma has said, that voting by proxy, you can't find it anywhere in the standing orders of the County Assembly or anywhere else. And yet, this is going to guide us to decide on your PO, Mr. Mutuma. Don't you think reading standing order in its entirety, we should give the County Assembly an opportunity to demonstrate to the House that the Speaker proceeded under standing order number 1 of the County Assembly, allowed by proxy, and maybe he did so because of some usage, some tradition that preceded that decision. Don't you think we should allow this to proceed so that we hear evidence to make a decision instead of just condemning them? No, you are wrong.
Counsel for Governor, you have a few seconds to respond.
Thank you, Senator Boni Khalwale. An argument based on points of law or the interpretation of law cannot be a factual issue. It is based on legal arguments. They had that opportunity to submit, and that's why this Senate directed us to prepare written submissions and bring them before this House. That is why they've been given 20 minutes to demonstrate to you through legal arguments how the Speaker can rely on standing order number 1. There is no witness who is coming to testify on a question of law. It is purely an interpretation issue which does not require evidential interrogation. The purpose of going through a trial, honorable senators, is for you to look at the facts, to cross-examine the witnesses on their version of factual issues and then render a decision of fact. Questions of law.
Counsel for Governor, time
Thank
is
you.
up.
Thank you.
Now,
Thank you, Mr.
Honorable
Speaker.
Senators, I will be giving my ruling at 2:30 on this particular matter. All right.